Hello, my name is Benjamin Hart. I'm an American attorney and the managing director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing Amity Treaty companies and the notion of holding companies. So, can an Amity Treaty company be a holding company? Let's first dive into what is an Amity Treaty company. Well, pursuant to what's called the US-Thai Treaty of Amity between Thailand and America, Americans doing business in Thailand, or more specifically, American corporations in Thailand doing business here, are granted national treatment. What does this mean? Well, it means the company, so for example, if you set up a Thai company here in Thailand and you get Amity certification, that company will be treated as if it were a Thai company. It's just treated, it's given national treatment. So notwithstanding the provisions of the Foreign Business Act, which usually practically result in people needing to set up their company 49-51 foreign to Thai ratio, notwithstanding those provisions, Americans can basically own their companies 100% under the Amity Treaty setup. So what's the point of this video insofar as holding companies? What are we talking about? Well, Amity Treaty companies are treated as if they were Thai companies, and especially from an operational standpoint, it operates quite smoothly. I mean, there's no real issue. If you have an Amity company, you just do business just like a Thai company would. Now, the issue comes in when you'd have a company acting as a kind of a holding company. So first off, let's be clear. Sometimes people talk about holding companies and they're talking about property holding companies like land, for example. Well, land ownership is specifically prohibited under the Amity Treaty, so you're not going to be able to set up an Amity company and circumvent the Thai restrictions on land ownership as a holding company. The next sort of issue is a little bit more nuanced insofar as an Amity company acting as a holding company insofar as they're holding shares in another corporation in Thailand. And this is where I've seen people say, well, why can't we set up an Amity company that'll then own a majority of another Thai company that doesn't have Amity certification, and that Amity company can own it 100% because it's granted national treatment. I have seen where the Thai bureaucracy, if you will, or in circumstances where this issue has to kind of be arbitrated, where they've said, look, Amity Protection flows to that one entity. It's not like a flow-through thing. So you can't do through using an Amity company as a holding company to then own a company that does something that is perhaps in violation of the Foreign Business Act without getting that other company specifically certified. There's no like flow-through Amity Protection or anything. So in that sense, no, they can't act as holding companies and allow that other company to just operate as it otherwise would as a Thai company. No. It's treated as foreign in the sense for those purposes. Amity certification certifies the specific company, the specific entity which covers it. It does not flow through. That's the best way to understand this in a holding company context.